On behalf of Advocates Bar Associations, I am also thankful to our lecturer, Honorable Guest Lecturer Sri Dr. Rajendra Anbhule, that they are present here of his busiest schedule for delivering the lecture on law, precedent and trial court practice on the occasion of late Shri D.S. PARIKH. So, on behalf of all adequate members, I am requesting our Secretary, Samir Ramanka sir, to present bouquet to our guest, Rajendra Anbhule. So kindly, working hand. So this lecture series is very much demanding and there is a much response from our adequate members, as well as there are number of lecturers are coming here and they are delivering their lectures very smoothly and effectively, and number of adequate members are taking advantages of it. So and today I am requesting Dr. Rajendra Anbhule to give their guidance, their experience, whatever they are had in their entire education, qualification as well as their practice. And I am giving just introductions of our lecturer, Dr. Rajendra Anbhule. So I am going through this entire their education qualifications as well as their entire experience as an advocate. Dr. Rajendra Anbhule is a MA Political Science, LLM Gold Medalist, PhD in Law, so Advocate on Record of Supreme Court of India, completed MA in Political Science from Department of Political Science, University of Pune, stood second in University, did LLB from ILS Law College, Pune first class, was awarded the Best Student Award in the year 2000. LLM from University of Pune, stood first in LLM examination among all the successful candidates securing gold medal. So there are number of degrees they are having, as well as there is a much more experience as a lecturer. Handled all kinds of cases pertaining to constitutional law, civil law, criminal laws, land laws, labor laws, trust laws, personal laws, commercial laws, service and educational laws, admission laws. Honorary Director of Center for Advanced Legal Studies, Training and Research, National Law University, Bombay. Member of Board Studies in Faculty of Law at Bharatiya Vidyapith, Pune. Written several books on various law subjects. Acted as a resource person for Bharat Ashram Mahashaya Goa, Ishtada, Pune. State Women Commission, Women and Child Development Department, Master Police Training Center, Police Research Center, State Intelligence Bureau, and other different institutions. So they have lot of experience for their entire career, as well as they are devoted for their न्यायदेवतेने त्यांनी डिवोट केलेलं आहे त्यांच्या पूर्ण करिअर शेड्यूलमध्ये आणि त्यांनी जे त्यांचं काम चांगल्याप्रकारे बजावत आहे. सो आय एम रिक्वेस्टिंग द ऑनरेबल सेक्रेटरी सो आय एम रिक्वेस्टिंग टुडेज लेक्चरर श्री राजेंद्र अनबुले to come to the and deliver the lecture. Thank you.
Respected dais, all my dear friends. The topic which has been given to me for today's discussion is a topic of practical importance. In trial court practice, if the provision of any particular law is vague, then we are always referring to some judgments of Supreme Court and High Courts in support of our case. Sometimes we may refer a judgment by merely reading a edit note of any particular journal, law journal, which is not a correct practice. In today's discussion, I am going to discuss what the law of precedent means, what kind of precedents are applicable in India, what are the general principles involved by Supreme Courts and High Courts in dealing with this particular law, what constitutional provision says, and ultimately what exceptions are there to this doctrine of precedent. In political science, there is a theory of separation of power which has been laid down by Montesquieu. And Montesquieu says that in every democratic legal system there are three organs of the state. First is legislature, second is executive, and third is judiciary. Legislature has to make laws, executive has to implement the laws made by legislature, and judiciary has to interpret the laws which are made by legislature. And according to Montesquieu, as far as the separation of these powers are concerned, one organ should not interfere in the working of another organ. It means that when Parliament is making laws, when legislature is making laws, executive should not interfere in that. Judiciary should not interfere in that. One organ should not interfere in the working of another organ. But in India, that is not practically possible when our constitution speaks about checks and balances. So balancing of powers of various authorities like executive, judiciary and parliament is very much incorporated in the provisions of our constitution. Now you are aware that Supreme Court of India is final court of appeal, and law declared by Supreme Court is law of the land. Now Montesquieu is saying that one organ should not interfere in the working of another organ means that legislature shall make laws, executive and judiciary shall not deal with making of laws, because that is the work of the legislature. Now nowadays, as I said earlier, that this kind of strict separation of power is not applicable in India when checks and balances are required for smooth functioning of our constitution. So today the fact is that even executive is also making laws. If you see Article 13 Clause 3 of the Constitution, 13 Clause 3 says law includes ordinance, regulations, bylaws and notifications. Now this is in form of delegated legislation. So this delegated legislation is recognized as a law by constitutional law itself in Article 13 Clause 3, and Article 13 Clause 2 says that Parliament shall not make any law or states shall not make any law which takes away or abridges the rights guaranteed by Part 3 of the Constitution, and any law made by state is void to the extent of that contravention. So, as I said earlier, that Supreme Court is the highest court of appeal, and any law laid down by Supreme Court is law of the land. Now, very importantly, our legal system is based on the legal system of United Kingdom. In England, common law was developed by principles, and that was in absence of codified laws. In India, Government of India Act was enacted in 1935, and if you see section 212 of the Government of India Act 1935, it says that law declared by Privy Council and Federal Court is binding on all the courts within the territory of India. See the wording. Law declared by whom? By Privy Council and Federal Court. In India, that time in 1935, Federal Court was the highest court of appeal in India, and after commencement of the Constitution, Supreme Court of India took place of Federal Court. So Federal Court was substituted by Supreme Court of India when Constitution was commenced on 26th of January 1950. So this section 212 says that law declared by Federal Court and Privy Council is binding on all the courts within the territory of India. That was a pre-constitutional law in 1935. As I said earlier, that on 26th of January 1950, Constitution of India came into existence. And this law, constitutional law, which is a fundamental basic law of our country, has laid down a new hierarchy in our judicial system. At the apex level, Supreme Court of India is there. At the state level, high courts are there. At district level, district courts are there. At taluka level, judicial magistrate first class are there. Hierarchy is there. Now in this hierarchy, Supreme Court is the highest court of appeal as far as constitutional provisions are concerned. Now coming to the topic, law precedent. Now before discussing what law precedent is, let me discuss what Constitution says. Please come to Article 141. Article 141 says that law declared by Supreme Court is binding on all the courts within the territory of India. See the wording of 1935 Act, section 212. What it says? Law declared by Privy Council and Federal Court is binding on all the courts within the territory of India. Now Article 141 replaces that and says that law declared by Supreme Court is binding on all the courts within the territory of India. Now please see Article 129 of the Constitution in connection with 141. And Article 129 says that Supreme Court of India is a court of record and it has a power to punish for the contempt of itself. See the nexus, connection, relationship. What 129 says? 129 says Supreme Court of India is a court of record and it has a power to punish for the contempt of itself. It means that if any law is declared by Supreme Court of India under Article 141 of the Constitution, and if the order passed by Supreme Court under Article 141 is not followed, if it is not implemented, if not complied, if not followed, then section Article 129 comes into operation. And it says that Supreme Court is a court of record and it has a power to punish for its contempt. In constitutional law, there is no provision about binding effect of judgment given by High Court on trial courts. 141 says that law declared by Supreme Court is binding on all the courts within the territory of India, but there is no section in the Constitution or article in the Constitution which says that the law declared by High Court is binding on trial courts. Now Supreme Court has decided in category of cases that whenever any judgment is passed by High Court, then it is binding on trial court as per Article 227 of the Constitution. Because according to Article 227 of the Constitution, High Court is having power of superintendence over all the trial courts and tribunals within the territory of that states. That's why any judgment given by High Court is binding on lower courts and tribunals because of the supervisory jurisdiction which the High Court is exercising under Article 226 of the Constitution. And again, to support the authority of High Court in relation to Article 227, there is another article, that is Article 215. And Article 215 says that High Court is a court of record and High Court has a power to punish for the contempt of itself. It means that Article 215 is similar to Article 129 of the Constitution. Only difference is that power to punish for contempt is given to Supreme Court under Article 129 and the same powers are given to High Courts by Article 215 of the Constitution. So the binding effect of any judgment given by Supreme Court on trial courts is in relation to 141 and in relation to High Court, that is Article 227, because High Courts are exercising power of superintendence. Supervisory powers are there with the High Court on all the trial courts, including even the tribunals. Now the issue is, what is precedent and how that particular authority flows in India? I said earlier that there is a hierarchy in India. At the apex level, Supreme Court is there. At the state level, High Courts are there. At the district level, trial courts are there. Now, a judgment given by trial court cannot be treated as a precedent for the reason that it is not a court of record like High Court and Supreme Court under Article 129 and 215 respectively. That's why the judgments of trial courts are not reported judgments, because it is not a court of record, but that power is there with High Court under Article 215 and Supreme Court under Article 129 of the Constitution. If a judgment is given by larger bench of Supreme Court, presume for some time 5 judges. Whenever there are 5 judges or more than 5 judges, then it is known as a constitutional bench, Ghatna Pit. If 5 judges are there, then it is known as a constitutional bench, and any subject matter of constitutional importance can be decided by 5-judge bench. A judgment given by 5-judge bench of Supreme Court is binding on full bench of Supreme Court. Full bench means 3 judges. Division bench of Supreme Court, even on High Courts and even on trial courts. See how the authority is flowing from up to down. If a judgment is given by 5 judges of Supreme Court, it is binding on 3 judges of Supreme Court, division bench of Supreme Court, on High Court and even on trial courts. If a judgment is given by High Court, then it is binding on trial courts. Now, so far as persuasive judgments are concerned, that I will discuss in latter part. Always remember one thing. The issue is, can it be said that a judgment is given by division bench of Supreme Court of India or division bench of Bombay High Court, and a single bench of Bombay High Court don't want to follow the judgment given by division bench of Bombay High Court? In that case, can he do so? Now, law precedent says that if uniformity is to be achieved properly in spirit, then normally a single bench cannot ignore a judgment given by division bench. He has to follow that because it is binding on him. And very importantly, if he is not going to follow that, then that judgment of that given by single bench will amount to judgment per incurium. Now, what is per incurium? I will discuss after some time. But the thing is that as a judicial discipline, single judge has to follow the judgment given by division bench. Division bench has to follow the judgment given by full bench or constitutional bench. But under certain circumstances, they may not follow that. And for that reason, I am going to discuss 5 important rules. Number 1, a single bench of Bombay High Court is bound to follow the judgment given by division bench of Bombay High Court. But if he don't want to follow that, if he is of the opinion that the judgment given by division bench is not correct, then law precedent says the proper recourse which is available to him is that he has to refer that particular matter to Chief Justice for constitution of a larger bench. Number 1. Number 2, a single bench is bound to follow a judgment given by full bench, 3 judges. But if he disagree, then he has to put all the papers before the Chief Justice for the consideration that whether larger bench is to be constituted in this particular matter or not. Number 3, division bench is bound to follow judgment given by another division bench, but if they disagree, then they can refer that matter to Chief Justice for constitution of a larger bench. Number 4, division bench has to follow the judgment given by full bench, but if they disagree, then division bench has to put the papers before Chief Justice for consideration whether larger bench is to be constituted or not. And number 5, that is very important, one full bench is bound by the decision given by another full bench unless that decision is overruled. One full bench is bound by the judgment of another full bench unless that judgment is overruled. And in law precedent, overruling can be there only by larger bench. The judgment given by 3 judges can be overruled by 5, of 5 by 7, of 7 by 9, of 9 by 11. That is a rule as far as law precedent is concerned. Now coming to most important aspect, what is law precedent? Normally, when a judgment is given by Supreme Court of India or given by the High Court, that judgment can be divided in 3 parts. Number 1, finding of material facts. Number 2, principle of law evolved by the court in that case. And number 3, operative order or judgment or final order. 3 parts are there in every judgment. Finding of material facts is the first part. Principle of law evolved by the court in that case is the second part. And third part is operative order, that bail allowed, bail dismissed, whatever it may be, bail rejected or petition dismissed. That is the operative order. Now the question is, in trial court, when we are referring any judgment of High Court or Supreme Court, what is to be treated as a precedent? What should be read before the trial court as a ratio of that particular case? And Supreme Court and High Court has clarified in category of cases, it is not the first part which is to be treated as a precedent. It is not the third part which is to be treated as a precedent. It is the second part, middle part, principle of law evolved by the court, reasoning given by the court in relation to law, that shall be treated as a precedent. That's why law precedent means reasoning given by the court by supporting any particular legal provision. Principles of law evolved by the court in that particular case. So first part, finding of material facts, and third part, operative order, cannot be treated as a law in terms of law precedent. I'll give a simple example. In Supreme Court of India, sometime special leave petition may be dismissed in limine or by passing a reason order. There was a judgment given by Supreme Court of India which was in favor of landlord. The order of 20 pages was in favor of landlord. But when operative order was passed, the tenant was given 6 months time to vacate the premises. And when the matter was over, the tenant was literally saying that it is me who has won the case, because I was thinking that Supreme Court will give only 1 month time to me, but they have given 6 months time to me. And finally justice is given to me, not to the petitioner in that case. This is known as molding of relief. So court may mold the relief under Article 136 of the Constitution by resorting to 142 of the Constitution with a view to do better justice to the parties in question. That's why what I want to say is that the first part in judgment, finding of material facts, shall not be treated as a precedent, and the last part, which is third, that is operative order, cannot be treated as a precedent, but the middle part, reasoning given by the court, principle of law evolved by the court, any law discussed by the court in that case shall be treated as a precedent. In simple words, Muslim wife is entitled to claim maintenance under section 125 of CRPC is a principle of law evolved by Supreme Court of India in Shah Bano case. Muslim wife is entitled to claim maintenance under section 125 of CRPC. Is a ratio, is a principle of law, is a law precedent evolved by Supreme Court of India in Shah Bano case. That's why, very importantly, whenever law precedent is there, 2 things are there. Number 1, court has given reasoning wherein principle of law is evolved, and that principle of law is evolved secondly in relation to the facts of that particular case. That's why law precedent shall not be confused with operative order in any particular judgment or even finding of material facts. Whatever principles of law are evolved are known as ratio decidendi, ratio of the case, and that ratio itself can be argued in a trial court in support of your client at the time of discussing any particular matter. Now, very importantly, a judgment can be divided in two parts. First is ratio. Ratio is nothing but principle of law evolved by the court, which is the second aspect, middle aspect. And second is arbiter dicta. Now, arbiter dicta may not be binding on the court. How it is binding, that also I will discuss in latter part. But arbiter dicta is of three parts. Number one, judicial dicta. Number two, dicta persona. And number three, dicta gratis. Again I am saying, number one, judicial dicta. Number two, dicta persona. And number three, dicta gratis. According to Supreme Court of India, only judicial dicta is binding on trial courts and high courts. So far as another dicta is concerned, dicta persona. Dicta persona is nothing but personal opinion of that judge in relation to that particular facts. And dicta gratis means something which has been observed by the court which is not relevant to that particular case also. That's why dicta persona and dicta gratis cannot be treated as a law in terms of Article 141 of the Constitution of India. Now, as I said earlier, that law precedent in India is having base in Article 141 of the Constitution of India, and Article 141 says that law declared by Supreme Court is binding on all the courts within the territory of India. Right from 1950 till 1978, Supreme Court of India was highly influenced by analytical legal positivism of Austin. In jurisprudence, there is a theory of legal positivism, and that in that legal positivism theory, John Austin, Kelson, Hegel, Bentham, Jeremy Bentham are the supporters of that particular theory. John Austin says that law is a command of sovereign addressed to the people which is secured by physical force of the state. Law is a command of sovereign, and according to Austin, in India, command of sovereign is nothing but a will of Parliament of India. So whatever Parliament of India is saying is a supreme law, and that is binding on everybody, and if it is not followed, then punishment is prescribed by that. That's why Indian Penal Code is there, wherein punishment is prescribed and law is made by the legislature. After 1978, the attitude of Supreme Court was changed. A new theory was adopted by rejecting analytical legal positivism of Austin. You know, even Justice Rajendra Anbhule has said in so many cases that we are here as a servant of the legislature. We are here only to interpret the law. We cannot make something new. But Article 141 is saying that Supreme Court can declare the law. That's why in 1978, when Menaka Gandhi versus Union of India was decided, Supreme Court of India, by its activist zeal, expanded meaning of Article 141, and Supreme Court of India accepted new theory, that is American legal realism. American legal realism says that yes, judges are lawmakers. Judge can make law. Judge can make law. And this particular theory says that the place where the judges are sitting is not a courtroom. The place where the judges are sitting is not a courtroom. It is a laboratory where the law is every day retested, refined, revived by them. And they says that bad man is not concerned. Bad man means a person who has violated the law, like accused. That bad man is not concerned with what is there in the book. He is concerned what the judge will decide and how he will decide. So, some sort of activism was inserted by American legal realism in judicial lawmaking. And this particular judicial lawmaking says, very importantly, that judges are lawmakers. Judges are lawmakers. When Menaka Gandhi was decided in 1978, Supreme Court of India held that even though the word due is not there in Article 21 of the Constitution, it shall be read. And any procedure adopted by the state, if not just fair and reasonable, but if it is arbitrary, it can be set aside. And there is nexus between Article 21, Article 19 and Article 14 of the Constitution. Inclusivity of fundamental right was a principle evolved by Supreme Court of India in Menaka Gandhi case. And the procedural safeguards which are there in Article 21 and even in CRPC of 1973 are equally applicable to every accused person was held by Supreme Court later in D.K. Basu versus State of West Bengal in 1997 when the case was in relation to arrest and detention matters. So 4 rights are there in Article 22. Number 1, if a person is arrested, he shall be given reason of the arrest. Number 2, he shall have opportunity to consult a lawyer of his own choice. He shall be brought before the court within 24 hours excluding the time of journey. And if detention is required beyond 24 hours, it can be there only by the order of the magistrate. Similar provisions are there even in CRPC, which is also basically a human right law. So Supreme Court has clarified after Menaka Gandhi case, wherein the human right jurisprudence was evolved in leaps and bounds, that executive is bound to follow the principles of natural justice. And because of that, even Article 141 was also widened. That law declared by Supreme Court is binding on all the courts within the territory of India. What it means? It means that, number 1, if any judgment is passed by Supreme Court of India under Article 141, again I am saying, please go to second important aspect in relation to 3 categories. Finding of material fact is not a law. Operative order is not a law. Reasoning given by the case in relation to that particular principles of law is a law precedent. That's why Article 141 says that law declared by Supreme Court is binding on all the courts within the territory of India. Now very importantly, what principles are evolved by court in relation to Article 141? Number 1, if any judgment is given by Supreme Court of India under Article 141, then it is binding on all the courts within the territory of India, including tribunals. Number 2, Supreme Court is not bound by its own decision, because Supreme Court can overrule its own decision. I will come to that point. Number 3, only a ratio laid down by Supreme Court of India is binding. Number 4, a judgment given by Supreme Court is binding even on non-parties. That's why law precedent. That's why law precedent. It is binding on non-parties. Number 5, minority judgment is not binding as a law. It is the majority judgment which is binding. In a case, sometime it may happen there are 5 judges. What 3 judges are saying is majority, what 2 judges are saying is minority. That's why law precedent is majority judgment, not minority judgment. But in India, it has happened so many times that in future, minority law has become a majority law. That's why when Menaka Gandhi was decided in 1978 by Supreme Court of India, Supreme Court of India overruled Gopalan versus State of Madras of 1950. And what Justice Fazal Ali said in Gopalan as a dissenting judgment, minority judgment become a majority judgment in Menaka Gandhi case. That's why sometimes it may happen that a judgment which is minority one may be a majority one in future if it is overruled. If you see Article 145 Clause 5 of the Constitution, 1455, there is a provision that every judge of Supreme Court and High Court is entitled, is authorized to give its own judgment. They can give their separate judgments or minority judgments. And these minority or dissenting judgments are recognized by Article 145 Clause 5 of the Constitution. So that is the 6th important rule. 7th important rule is that, which is very, very important, if any judgment of Supreme Court of India is noted and explained by High Court, if noted and explained by High Court, then also judgment of High Court is to be treated as a binding precedent. And number 7, last aspect is very important. If any Supreme Court judgment is added, if something new is added by High Court to that particular judgment of Supreme Court by noting that, then even that particular judgment of High Court can be treated as a binding precedent. I'll give a simple example. Supreme Court of India is saying that wife is entitled to claim alternative accommodation under section 19 of the Protection of Women from Domestic Violence Act. And that is her basic right, which is higher one in the light of section 17 of the Act. Because section 17 also deals with right of precedence, which is a higher right which cannot be taken away except as provided by law. Now Supreme Court has recognized right of alternative accommodation, and Supreme Court has said that when right of alternative accommodation is granted to wife, she is entitled to claim rent. That is a ratio laid down by the court, wherein section 19 of the Act has been properly applied by the court. Now Bombay High Court has given another judgment on the basis of Supreme Court judgment, and Bombay High Court is now saying that not only the rent in form of alternative accommodation, but wife is entitled to get even deposit also for that particular flat. So Bombay High Court is adding something to the judgment given by Supreme Court of India, to which the Supreme Court is saying that if something is added, then it cannot be said that our judgment is disregarded. If our judgment is noted and if something has been added in that, it can be treated as a binding precedent. That is also a very important law in relation to our discussion so far as law precedent is concerned. Now after discussing all this, another important aspect is there in discussion, that is categories of law precedent or kinds of precedent. And for today's discussion, I will confine it to three important categories. Number one, original precedent. Number two, authoritative precedent. And number three, persuasive precedent. Now coming to first, what is original? A law is there in any particular statute, but the provision is vague. The provision is not given proper meaning. If you read that provision, you will not come to know how to apply it. Let me give you example. If you see section 11 of the Indian Contract Act 1872, that section 11 says every person is competent to contract who is of the age of majority according to the law to which he is subject, who is of sound mind, and who is not disqualified by law from contracting to which he is subject. So section 11 of the Indian Contract Act says that minor is incompetent to contract, a person of unsound mind is incompetent to contract, and a person disqualified by law from contracting is incompetent to contract. But tell me one thing, whether section 11 is saying that minor's agreement is void? It doesn't say. Section 11 only says that minor is incompetent to contract. Competency is discussed by section 11, but what are the repercussions, what are the consequences of minor's agreement is not discussed by section 11 of the Act. Now Indian Contract Act discusses about void agreement, it discusses about voidable agreement, it discusses about unlawful agreement, it discusses about unenforceable agreement, but section 11 nowhere says that minor agreement is void, minor agreement is voidable, minor agreement is unlawful. Section 11 only says minor is incompetent to contract. In 1903, see the law is of 1872. In 1903, in Mori Bibi versus Dharamdas Ghosh case, it was held by the court that minor's agreement is void ab initio. Law is of 1872 and section 11 of the Indian Contract Act has been interpreted properly by the court in 1903 after the gap of 30 years, more than 30 years. And now the law has been settled that minor agreement is void under section 11 of the Indian Contract Act. Mori Bibi can be treated as a original precedent. Why? Because for first time in the history of section 11, the court has clarified that minor's agreement is void. That's why if a law is laid down for first time by the court defining any particular provision, then that is known as original precedent. Original precedent. But in another case, any judgment given by Supreme Court of India is binding on high courts and trial courts which is known as authoritative precedent. Authoritative, as the authority it is binding. And third is persuasive. What is persuasive? Persuasive is exercised in relation to equal courts. In simple words, Bombay High Court may accept or may not accept the judgment given by Delhi High Court, because the judgment of Delhi High Court is having persuasive value. Persuasive means it is binding or it may not be binding. So Bombay High Court may follow that or may not follow. Bombay High Court may reject that particular judgment. That is known as persuasive value. When a judgment may be binding or may not be binding, or when one court is having discretion whether to apply that particular judgment or not, that judgment is having persuasive value. It may not have binding effect. But that is in relation to the high courts, not in relation to the trial court. Let me give a simple example. Presume for some time that you are arguing one case in City Civil Court of Bombay here. There is no authority of Bombay High Court on that point, which is a parental high court for us under Article 227 of the Constitution of India. But there is a judgment of Calcutta High Court which you are referring. And you referred that judgment before the court by saying that, Your Honor, there is no parental authority of Bombay High Court in relation to this particular facts. But I have a judgment of Calcutta High Court which is supporting my case. And the trial court says that this judgment is not binding on me because this judgment is not given by parental High Court of Bombay. Bombay High Court is saying if such things are happening, then the trial court judge is liable for disciplinary action. It is for the reason that when any judgment of parental high court is not there in existence in relation to any particular provision, you can refer any judgment of another high court which is supporting your case. Persuasiveness is in relation to the same courts in the hierarchy. That persuasiveness cannot be claimed by trial court. It is a law decided by Supreme Court of India in relation to law precedent. That's why if parental high court law is not there in relation to your case, then you can refer any judgment given by another high court to support your case, and that particular judgment is equally binding on the trial courts, even though there is no judgment of Bombay High Court on that particular issue. After this, now I am coming to most important aspect of today's discussion, that when this doctrine of precedent can be ignored in India. And the first important aspect for today's discussion is Article 142 of the Constitution. While referring any judgment before trial court, please see whether the case is disposed by Supreme Court under Article 141 or under Article 142. If a judgment is given by Supreme Court under Article 142, then it is not a binding precedent, because Article 142 says that Supreme Court of India can pass any judgment or decree with a view to do complete justice to the parties in question, and any judgment or decree passed by Supreme Court under Article 142 of the Constitution is enforceable throughout the territory of India. Judgment given by Article 142 or under Article 142 is a judgment given with a view to achieve end of justice. Supreme Court may give divorce in a special leave petition by applying Article 142 of the Constitution. In that case, any judgment given by Supreme Court of India cannot be treated as a law precedent under Article 142. Always remember, only judgment given under Article 141 are treated as a binding precedent. There are more than 100 of judgments of Supreme Court of India, wherein Supreme Court of India has clarified that whenever we are deciding something under Article 142 of the Constitution, we are exercising extraordinary jurisdiction with a view to achieve complete justice to the parties in question. That's why any judgment given by us under Article 142 cannot be treated as a binding precedent. Number one. Number two, a overruled judgment cannot be treated as a binding precedent. As I said earlier, I will give a simple example. In 2007, Supreme Court of India decided one landmark case, Batra versus Batra, in Domestic Violence Act. Supreme Court of India discussed section 2S of the Domestic Violence Act, and court clarified that wife is not entitled to claim right of residence in the house of in-laws. Wife is not entitled to claim right of residence in the house of in-laws, father-in-law and mother-in-law. This judgment of Batra of 2007 is overruled by Supreme Court of India in 2021 when Satish Ahuja versus Sneha was decided. And in Satish Ahuja case in 2021, Supreme Court of India said that Batra was wrongly decided by us. See what the gap is there. Batra is of 2007. In 2021, Supreme Court of India is saying that we were incorrect when we decided Batra. Meanwhile, from 2007 till 2022, so many applications were filed under Domestic Violence Act claiming right of residence in the house of in-laws, which came to be rejected. And in 2021, now Supreme Court of India clarified that Batra is wrongly decided by us, and wife is now entitled to claim right of residence in the house of in-laws. It means that in terms of Satish Ahuja case, Batra is no longer a good law, which is decided in 2007. That's why Batra is a overruled case. So Batra cannot be treated as a law precedent. Second. Third, a judgment reverse. A judgment which is reverse cannot be treated as a binding precedent. In simple language, in 2015, Bombay High Court convicted a person for murder, giving him life imprisonment. He approached to Supreme Court of India, and in 2023 January, presume for some time, that Supreme Court of India quashed the order of Bombay High Court, and that person was acquitted. The judgment of 2015 of Bombay High Court was reported in Law Journal. It was a binding precedent. But when that particular conviction is set aside by Supreme Court of India in appeal, we can say that the judgment of Bombay High Court has been now reversed. And when reversal is there, that particular reverse order cannot be treated as a binding precedent. Third important aspect. First was Article 142, second was overruling, and third was reversal. There is difference between overruling and reversal. Please note that. Number 4. A judgment per incurium. A judgment per incurium cannot be treated as a law precedent. Let me explain what it is. If a judgment given by Supreme Court or High Court is in ignorance of any statutory provision, or if it is in ignorance of a law laid down by larger bench, then that particular judgment is treated as a judgment per incurium. I will give a simple example. There is a judgment of, suppose, Supreme Court of India, just we discussed that, Satish Ahuja case. That wife is entitled to claim right of residence in the house of in-laws. Now tomorrow, Bombay High Court has given the judgment that wife cannot claim right of residence in the house of in-laws. And this Satish Ahuja judgment is ignored by Bombay High Court. In that case, the judgment of Bombay High Court can be treated as a judgment per incurium, which cannot be treated as a law precedent. You shall ignore that. So, in simple words, we may say, per incurium is that wherein judgment given by larger bench is ignored, or any particular statutory provision is ignored by the court. Coming to next aspect. A judgment sub silentio. A judgment sub silentio. What it means? Sub silentio. A matter is before the court, Inderjit Ghirwal versus State of Punjab. I am explaining that. The issue was about voidness of marriage. Whether the marriage is void or not, that was the issue before the court. Argument was laid down there. Defense also argued the case. Pleadings were complete. In entire case, there was no discussion about the limitation. The discussion only was whether the marriage is void or not. And Supreme Court of India held in Inderjit Gerwal case in 2011 that the marriage was void, because of which application filed by that lady under section 12 of the Domestic Violence Act is not maintainable. So the issue was about voidness of marriage. But in Inderjit Gerwal case, Supreme Court inserted one line, and that one line was section 468 of CRPC is applicable to domestic violence case. Now what is section 468 of CRPC? Section 468 speaks about limitation. It means that limitation under section 468 is applicable to domestic violence case. If you are not filing case within 1 year, then limitation has been lapsed. You cannot avail the remedy which is there under section 11 of the Act. In terms of law precedent, if the point is not argued, if the point is not discussed, if the point is not agitated before the court of law, if there is no pleading at all, and if something is said by the court, that can be treated as a judgment sub silentio, which cannot be treated as a precedent under Article 141 of the Constitution. That's why when court is silent at the time of trying the case, at the time of trial of the case, at the time of argument of the case, at the time of pleading of the case, if nothing has been discussed there that time, even petitioner also did not utter a single word on limitation, respondent also did not utter even a single word, but court is saying limitation is applicable. That is sub silentio judgment in terms of law under we may say Article 141 of the Constitution, which is not binding on trial courts. Coming to next part, that is very important, and it is in relation to interim order passed by the court. Now the issue is, presume for some time that a petition is filed in High Court or Supreme Court, wherein interim order is passed by the court, rule is issued, and matter is pending for hearing, for final hearing. Now the issue is whether interim order passed by the court can be treated as a precedent under Article 141 or Article 227 respectively. And the answer is, interim order cannot be treated as a law, but in interim order, if law is discussed by the court, then it is binding as a precedent. So in simple words, interim order as such cannot be treated as a precedent, but while passing interim order, if something is laid down by court in relation to any particular legal provision, or if any legal principle is evolved in interim order, then Supreme Court of India is saying that even interim order can be treated as a law precedent, and it can be even applied in trial court practice. Next part is there, that is distinguishing of a judgment. Now what is distinguishing? I will support my discussion in relation to two important case laws, which are the landmark case laws in relation to relationship in the nature of marriage. Domestic Violence Act does not recognize live-in relationship as such. Live-in relationship, that is not recognized as such. But Supreme Court has clarified that under certain circumstances, relationship in the nature of marriage can be recognized. If you read Article 2Q of the Domestic Violence Act, or Section 2Q of the Domestic Violence Act, Section 2Q says that respondent means any adult male person who is having domestic relationship with the applicant against whom she has filed complaint under the provision of the Act. Provided that, there is one proviso in Section 2Q of the Domestic Violence Act, provided that a wife or a woman having relationship in the nature of marriage may file complaint against relatives of the husband or relatives of the male partner. According to that proviso, wife can file complaint against relatives of the husband, or another category is there that a lady is there, a woman is there who has not married. Without marriage, she is residing with a male partner, and section 2Q is saying that without marriage, in absence of marriage, she is entitled to file application against that male partner and his relatives. So far as first part is concerned of section 2Q, respondent means any adult male person. 3 words, adult male person. These 3 words are struck down by Supreme Court of India in Hiralal Harsora case by applying doctrine of severability. So these 3 words are now not there in our section 2Q of the Domestic Violence Act, but second part is there, that is proviso. Now what is relationship in the nature of marriage? लग्नासारखे संबंध म्हणजे काय? That is not discussed by Domestic Violence Act anywhere. There is no explanation given by section 2Q. There is no schedule attached, any form attached to the Domestic Violence Act wherein relationship in the nature of marriage has been discussed. Finally, in 2010, one landmark case was decided by Supreme Court of India, that is Velusamy case. And in Velusamy case, in 2010, Supreme Court of India laid down 4 important parameters to decide when that lady will file complaint against the male partner. Number 1, both must be major. That male partner and that lady, both must be major. Number 2, both must be unmarried. Number 3, both must have resided in a shared household for any point of time. And number 4, society shall treat them as a spouse. These are the 4 parameters laid down by Supreme Court of India, in which case? Velusamy case of 2010. Again I am saying, number 1, both must be major. Number 2, both must be unmarried. Number 3, both must have resided in a shared household for any point of time. And number 4, society shall treat them as a spouse. If these 4 parameters are satisfied, then only any woman having relationship in the nature of marriage without marriage is entitled to file application under section 12 of the Domestic Violence Act. In terms of law precedent, Velusamy is a original precedent because what is the relationship in the nature of marriage has been decided by Supreme Court of India for first time in 2010. Next case was decided by Supreme Court of India in 2013, Indra Sharma case. In Indra Sharma case, one lady was working as an employee in one company wherein she was having affair or relationship with her boss. And she was aware that he was married. After having knowledge that he was married, she was having relationship with him. And subsequently, something was happened, the relationship becomes strained, and she filed application against him under section 12 of the Domestic Violence Act. Matter went to Supreme Court of India. In Indra Sharma case, Supreme Court of India distinguished Velusamy case. And Supreme Court of India held that in Indra Sharma case, that lady was aware that he was married. She was having information that he was married, still she was in relationship. That's why it cannot be treated as a relationship in the nature of marriage in the light of section 2Q of the Domestic Violence Act. Her case came to be dismissed. That's why when the material facts of 2 cases are totally different, when material facts of 2 cases are totally different from each other, then one case can be distinguished from another case. In that case, one case cannot be treated as a precedent for another case, is distinguishing of a case. Next aspect is there, that is abrogated decision. Abrogated decision cannot be treated as a law precedent. Let me give an example. I told earlier that in 1985, in Shahbano case, Supreme Court of India held that wife is entitled to claim maintenance under section 125 of CRPC. Within 1 year, in 1986, law was enacted, and the name of the law was the Muslim Women Protection of Rights on Divorce Act 1986. If you read section 2, 3, 4, 5 of that 1986 Act, that Act says that Muslim wife is not entitled to claim maintenance under section 125 of CRPC. It means that the judgment given by Supreme Court of India in Shah Bano is abrogated. Is abrogated because of this particular legislation enacted by Parliament of India in 1986. You know, in that 1986 Act, there is one section, that is section 5. That section 5 says that if at all, if that wife want to claim maintenance against the husband, against that Muslim husband under section 125 of CRPC, husband should have given consent to that. How husband will give consent to wife that please come to court, I am very serious and I want to pay maintenance to you. So expressly or impliedly, that right to maintenance which was there guaranteed by Shah Bano case has been taken away next year only, that is in 1986. So Shah Bano case in the light of 1986 Act is to be treated as a abrogated decision. So it cannot be treated as a binding precedent. Another category is there, that is consent orders. Suppose sometime there may be quashing of any particular complaint in the High Court under section 482 of the CRPC. So if any order is passed by High Court under section 482 of the CRPC by consent of the parties, then that consent order cannot be treated as a binding precedent on trial courts, and it cannot be even argued or applied in a given case. After this, last important aspect is there. While searching a case laws in relation to our client or while defending our client, sometimes we may come across several judgments of High Court and Supreme Court. Now presume for some time that in support of your client case, you found two case laws. One is of 2010 and another is of 2020. One is recent, another is old. Now which case is to be applied is a question before you. Gone were the days wherein it was said that old is gold. So 2010 judgment is to be applied. Later on the view was changed, wherein it was said that what is recent shall be followed in support of your case. But the present settled position is now something different, and Supreme Court of India has now clarified. The judgment may be old. Now the 2010 judgment is of division bench. 2020 judgment is also of division bench. Now you are in dilemma, you are in confusion that which is to be accepted. And Supreme Court of India is saying that the judgment may be old or it may be even recent. That judgment which is better in point of law, which suits you, shall be accepted and it can be argued in relation to your case. I am very much thankful to City Civil Court for giving me an opportunity to discuss the concept of law precedent. Thank you very much. Thank you.
I am very much thankful to our lecturer, Dr. Rajendra Anbhule, for delivering such type of nice lecture to all, and they are come here and give in-depth knowledge about this topic, and we are very much thankful to all our members for supporting this lecture series. I am requesting President, Honorable President Bhaskar Sarode, to hand over the memento to our guest, Dr. Anbhule. So I am requesting our Secretary Samir Sarmakar to give the vote of thanks on behalf of all our members.
Before that, if anybody want to ask any question, they can come forward and put the query. the speaker. राजेंद्र सर, तुमचं अभिनंदन. तुम्ही छान लेक्चर दिलं. तुमचा एकंदर अभ्यास खूप विषयावर चांगला आहे. भारतीय सर्वोच्च न्यायालयाने जे केस लॉज दिलेले आहेत त्याच्यामध्ये केशवानंद भारती विरुद्ध युनियन ऑफ इंडिया हा खूप महत्त्वाचा निर्णय आहे. आणि आतापर्यंत पार्लमेंटने अनेक लॉ नवीन बनवले. आपण शहाबानूंचा पण उल्लेख केला. तर ह्या केसचं महत्त्व एकंदर गोलकनाथ नंतर ती केस आलेली आहे. तर दोन्ही केसमधला फरक आणि नेमकं त्याच्यामधलं काय फॅक्ट्स आणि शेड्यूल 9 किंवा काय नक्की काय आहे ते आम्हाला समजून सांगा.
Basically, Keshavananda Bharati versus State of Kerala is a judgment given by Supreme Court of India in 1973. 13 judges were there, wherein Supreme Court of India, for the first time in the history of Indian judicial system, applied, or we may say invented, doctrine of basic structure. Before that, there was a judgment of Bombay High Court, Supreme Court of India of 1951, that is Shankri Prasad. In Shankri Prasad case of 1951, in some law journal it is reported in even 1950 also. The issue was, in India, who is supreme? Whether Parliament of India is supreme or whether Constitution is supreme. And if any part of the Constitution is to be amended, whether Parliament can do so by resorting to the powers which are given under Article 368. In Shankri Prasad, Supreme Court of India supported Parliament of India by saying that in India, it is the Parliament which is supreme, not the Constitution. And Parliament of India can amend any part of the Constitution, including even part 3rd of the Constitution. Same view was followed again in Sajjan Singh after Shankri Prasad. But in 1967, Supreme Court of India decided one landmark case, that is Golaknath versus State of Punjab. And in Golaknath case, Sajjan Singh and Shankri Prasad came to be overruled. And Supreme Court of India clarified that Parliament has no power to amend fundamental rights which are guaranteed by part 3rd of the Constitution by resorting to amending powers which are there in Article 368. In 1973, with a view to erase the efficacy of Golaknath case of 1967, Keshavananda Bharati was decided. In Keshavananda Bharati case, Supreme Court of India partly overruled Golaknath. Not fully, partly overruled. And Supreme Court of India clarified in Keshavananda Bharati case that yes, Parliament can amend any part of the Constitution, including fundamental rights, but Parliament cannot amend basic structure of the Constitution. What is basic structure is not decided by Supreme Court of India in Keshavananda Bharati. It is kept flexible. And on case-to-case basis approach, Supreme Court is inventing something new as a part of basic structure. So for the first time in the history of India, in Keshavananda Bharati, doctrine of basic structure was evolved. So rule of law, democracy, equality before law are held to be basic structure of the Constitution which cannot be amended. After Keshavananda Bharati in 1980, Supreme Court of India decided Minerva Mill versus Union of India. And in Minerva Mill case also, Supreme Court of India held that it is part 3rd of the Constitution which is superior, not part 4th, and both are supplementary and complementary to each other. And when Minerva Mill was decided by Supreme Court of India, it was clarified by the court that in India it is the Constitution which is supreme, not the Parliament. In 2014, you must be aware that Article 124A was inserted in the Constitution, wherein collegium system was abolished. NJAC Act, National Judicial Commission Act came into existence, and that NJAC Act was challenged in Supreme Court of India, wherein Supreme Court of India struck down that NJAC Act. Now in NJAC Act, the issue was in relation to the appointment of the judge. Supreme Court of India read appointment of judge in independence of judiciary, and Supreme Court of India held that it is a basic structure of the constitution. So this is a new form of basic structure which is known as derivative basic structural doctrine. Supreme Court of India derived appointment of judges in independence of judiciary. This is something new in India. Now as far as 1985 judgment of Shahbano case is concerned, there is a slight difference between fundamental rights and constitutional rights, and even constitutional rights and statutory rights. In this case of 1985 of Shahbano, the issue was not in relation to the fundamental rights. The issue was not in relation to the constitutional rights. The issue was in relation to the statutory right which was granted by section 125 of CRPC. That's why to limited extent Shahbano was decided. After 1986, when that law came into existence, that constitutional validity was also challenged. And in Daniel Latifi case of 2001, Supreme Court of India clarified that the provision of 1986 Act are constitutional, but Muslim wife is entitled to claim maintenance under that law, not only till the iddat period, but beyond iddat period also. And after that, I may say it is a cherry on the cake. If you read Domestic Violence Act provisions, this law is secular in nature, which has covered even Muslim women also. And it is, I may say that it is a uniform civil code under Article 44 of the Constitution of India, because it is equally applicable even to Muslim lady also. That's why there is a slight difference, we may say, between statutory right, constitutional right, fundamental rights, and even human rights. All human rights are not fundamental rights. If a human right is incorporated in the constitution, then only it can be treated as a fundamental right. Sometimes it may happen that you may have a human right, but it may not be a fundamental right. So it may not be enforceable under Article 32 of the Constitution. Thank you very much.
Thank you once again. I am grateful on behalf of the Bombay Civil and Sessions Court Bar Association for today's speaker, Dr. Rajendra. Sorry.
हेलो, मैं सर के परिचय के लिए थोड़ी सी बात कहना चाहता हूँ।
क्वेश्चन रहेगा तो पूछो।
क्वेश्चन नहीं पूछ रहा हूँ।
टाइम नहीं देखो।
सर मेरा क्वेश्चन है कि लार्जर पे आर्टिकल 226 टू 27 9 बेंच जो लार्जर बेंच में 227 में कि जुडिशियल ऑर्डर को एज नॉट सेंचुरियो बोल सकते हैं। बाद में अभी 4 लाख में जो 2 बेंच का 3 बेंच का जो जजमेंट आया सुप्रीम कोर्ट में, तो 227 के जुडिशियल ऑर्डर कैन बी 226 आर्टिकल 226। तो 9 बेंच का 1971 का जो जजमेंट है, 9 बेंच का जो जजमेंट है 227 का 1971 में, 227 ऑर्डर अंडर नॉट चैलेंज 226, तो रेफर तो 9 बेंच के जजमेंट को रेफर करना है कि अभी के जो जजमेंट को रेफर करना है?
Please clarify your question.
मेरा क्वेश्चन है कि जुडिशियल ऑर्डर को हाई कोर्ट में हम लोग चैलेंज करते हैं 227 226 आर्टिकल। तो 1971 में 9 बेंच का जजमेंट है कि जुडिशियल ऑर्डर को 226 में आप चैलेंज नहीं कर सकते। एनी ऑर्डर फॉर सबऑर्डिनेट कोर्ट तो 226 में आप उसको चैलेंज नहीं कर सकते, वो 227 में ही चैलेंज कर सकते। बट नाउ इन द प्रेजेंट चाबिना एक सम देवी का जजमेंट अभी जो लेटेस्ट है 2003 एंड 2015, तो 3 बेंच का जजमेंट बोलते हैं कि नहीं, आप वो जजमेंट 226 में चैलेंज कर सकते हैं। that is clarified. तो वो पूछ रहा है सर कि 226 में जो 9 बेंच को फॉलो करना है कि अभी 26 फॉलो करना है?
Any other questions?
Sir, what are your views about French civil law? In French civil law, as far as I know, there are no precedents followed in French civil law. We follow the British common law system. What do you think is better? Don't you think that the common law system where you have judicial precedents, it restricts the judicial creativity of the judges? What do you think is better among the two legal systems?
So according to me, the present Indian legal system is far better for the reason that there are some laws enacted by the Parliament of India wherein the provisions are not adequate. Some provisions are vague, very specific meaning is not given to them. So for proper interpretation of that, judiciary must have some power. Because if powers are not there with the judiciary, it will be very difficult to implement the laws effectively made by the Parliament. If you go to even Indian Evidence Act also, see the provision related to time declaration. Now the issue is, a statement given by a person on the verge of his death can be treated as a time declaration. But in some cases, there are more than one statement given by that person. The statement may be exculpatory or inculpatory. Now court has came to the conclusion that if there are more than one time declarations and if they are inconsistent in material particular, then that time declaration should be accepted, which is in favor of the accused. That's why very importantly, with a view to give clear meaning to the law, with a view to we will say bringing uniformity in law, the present Indian legal system is very much adequate. If there is arbitrariness, then court can always intervene.
Thank you very much. आम्हाला वाटतं कोणाला जास्त प्रश्न नाही आहेत. On behalf of our association, I am very grateful to today's speaker, Dr. Rajendra Anbhule, to give his valuable time for today's lecture. He was rather busy person, but today he agreed to come and enlighten us on various aspects of precedent. I think it is useful for our young colleagues also and for us also, because law is a learning process. We are doing law practice. So it is always helpful for everyone to go to take this knowledge and try implement it in our day-to-day matters. Once again, I take this opportunity to thank him, and also to the audience who is here with a large number to listen to this beautiful lecture. And special thanks to our colleague, Advocate Vijay Shekar, who is now the person who is arranging all these things and for coordinating with the speakers also. Thank you very much. Good night. Advocate Vijay Shekar. धन्यवाद सर. चहा पान झाल्यावर प्रोग्राम संपला. धन्यवाद.